Defamation. Paul, P., may bring a defamation claim against Dan, D. To prevail on a defamation claim, the plaintiff must prove 1. Defamatory statement, 2. Concerning the plaintiff, 3. Published to a third party. Additionally, if the defamation claim involves a matter of public concern, or a public figure, there are 2 additional elements that the plaintiff must prove in order to not run afoul of the First Amendment. The plaintiff must also prove 4. The statement is false, and 5. Made with malice, which will vary depending on the type of plaintiff. Defamatory statement. A defamatory statement is a statement that is reasonably likely to harm another's reputation. The statement generally must be one of fact. Statements of opinion may be actionable if they imply facts about the plaintiff. Concerning the plaintiff. A defamatory statement does not need to name the plaintiff specifically, as long as a reasonable person would know that the statement is referring to plaintiff. Published to a third party. The defamatory statement must also be published to a third party, which means that a third party must hear or read or perceive the statement. There are 2 types of defamation, libel and slander. Libel is when the defamatory statement is in a permanent format. Traditionally, libel included defamatory statements that were printed, but modernly, statements that are captured on television or the radio are also considered libel. Slander are spoken statements, not captured in a permanent format. Falsity of statement. When the plaintiff is a public figure, or the statement concerns a matter of public concern, then plaintiff also needs to prove falsity of the defamatory statement. As discussed above, P will likely be considered a public figure. D's intent. If the person is a public figure, or the matter is of public concern, the plaintiff will need to prove that the defendant acted with malice, which means that the defendant intentionally made the false defamatory statement, or made it with reckless disregard for the truth. If the plaintiff is a private figure, and the matter is of public concern, the plaintiff will need to prove that the defendant acted negligently when making the false defamatory statement. Damages. There are different rules regarding pleading of damages for libel and slander. General damages are presumed for libel. For slander, special damages are presumed where the defamatory statement falls into a slander per se category. I. About the person's profession or trade. 2. Infers that plaintiff suffers from a loathsome disease. 3. Accuses a woman of being unchaste. Otherwise, if the statement does not fall into the slander per se category, the plaintiff must specifically plead and prove damages. Intentional infliction of emotional distress, IIED. To prevail on an IIED claim, the plaintiff must prove 1. Defendant's outrageous and extreme conduct. 2. Caused the plaintiff to experience severe emotional distress. D's conduct. Conduct qualifies as extreme and outrageous if a reasonable person would find that it is offensive, and it would cause severe emotional distress in the reasonable person. Additionally, if the defendant has reason to know about the plaintiff's particular sensitivities, then the defendant's conduct, even if not offensive to a reasonable person, may still qualify as extreme and outrageous behavior. D's conduct caused P's severe emotional distress. For causation to exist, there must be both actual and proximate causation. Actual cause means that the defendant's conduct was either the but-for cause or substantial factor. But-for cause means that but for defendant's conduct the injury to plaintiff would not have occurred. Substantial factor occurs when there are multiple contributing factors, so it is impossible to determine the but-for cause and the plaintiff's injury, and defendant's conduct was a substantial factor in causing the injury. Proximate cause exists when the plaintiff's injury was a reasonably foreseeable result of defendant's conduct. Damages. If P is successful in proving his IAED claim, which is a close call but likely, then P will be able to recover damages from D. In a tort action, the plaintiff may recover compensatory damages, consequential damages, and incidental damages. These types of damages must be reasonably certain, caused, both actual and proximate, by defendant. A plaintiff has a duty to mitigate damages. False light. P may argue that D breached P's privacy by intentionally casting a statement to put P under a false light and misattributing a characteristic of dishonesty to him. False light requires that the act be highly offensive to a reasonable person. The same standard of fault of publisher applies as in defamation. Defamation, malice versus negligence, where the matter is of public concern. Strict liability puppy bite. Carol could claim that Dan is strictly liable for the injuries caused by the puppy who bit her hand. The owner of a wild animal is strictly liable for any injuries caused by the animal's dangerous propensities. A puppy would likely not be considered a wild animal for strict liability purposes. However, the owner of an animal with known dangerous propensities is also strictly liable for any damages caused by the animal's dangerous propensities. An owner will not be charged with knowing the dangerous propensities unless some circumstances exist which would give him reason to know of the animal's dangerous propensities, such as a prior incident of biting. Negligence. A prima facie case of negligence requires a showing of duty, breach, proximate, and actual causation, and damages. Duty. A duty of care is owed to all foreseeable plaintiffs. Where defendant's conduct poses a risk to the plaintiff, his duty of care will run to her. Under the majority view, a plaintiff is foreseeable if she is within the zone of danger created by the defendant's conduct. Under the minority view, a plaintiff is foreseeable if she is injured by defendant's conduct, regardless of whether she was in the zone of danger. Standard of care, licensee/invitee. The standard of care applicable to the defendant is based on the circumstances. The default standard of care is to act as a reasonably prudent person would under the circumstances. The defendant's standard of care can be increased based on the setting, and his relationship with the plaintiff. Owners or possessors of property are subject to stricter standards of care with respect to entrance upon their property. The specifically applicable standard depends upon the nature of the entry and the nature of the entrant. Licensees are those who enter onto the land of another with permission, for social purposes. Standard of care, invitee. Invitees are those who enter with permission, either to bestow an economic benefit upon the owner, or because the premises are held open to the general public. A landowner's duty of care owed to a business invitee requires him to make reasonable inspections of the premises, warn of any concealed dangers, and make the premises safe for invitees. However, landowners owe no duty to business invitees where invitees exceed the scope of their invitation, i.e. by entering an area marked Do Not Enter, or employees only. Breach. A defendant breaches his duty of care by failing to live up to the requisite standard of care. Actual cause. Actual cause, or legal cause, is determined under the but-for test. A defendant's breach will be the actual cause of the plaintiff's injuries if the plaintiff can demonstrate that, but for the defendant's breach, her injuries would not have occurred. Proximate causation. The defendant's conduct will be the proximate cause of the plaintiff's injuries where the injuries suffered were within the increased risk created by the defendant's conduct and were a foreseeable result of the defendant's conduct. Damages. Any personal injury or property damages are sufficient to support a claim of negligence. Duty, rescuer. In general, there is no duty to act affirmatively to come to a person's aid when they are injured. However, a landowner owes a duty of aid to injured business invitees on the premises. Further, where one does begin to render aid, he is under a duty to carry out the rendition of aid reasonably. Where a rescuer acts negligently in giving aid, he will be liable for damages caused by his negligence. Contributory negligence. A plaintiff is also required to act reasonably to prevent her own injuries. Contributory negligence will bar the plaintiff from recovery if the defendant can demonstrate that the plaintiff failed to live up to her own standard of care. Assumption of the risk. A plaintiff is similarly barred from recovering if the defendant can demonstrate that the plaintiff subjectively knew of the risk and proceeded anyway, despite that knowledge. Comparative negligence. Most jurisdictions have abandoned the harsh results of contributory negligence and assumption of the risk in favor of a comparative negligence regime. Under comparative negligence, if the jury finds that the plaintiff was at fault in causing her injuries, the jury will assign a percentage of fault to the plaintiff, and her recovery will be reduced proportionately to her percentage of fault. Under pure comparative negligence, a plaintiff will still be able to recover some damages, so long as the defendant is also negligent, regardless of the percentage of fault assigned to her by the jury. Under partial comparative negligence, when the plaintiff's degree of fault exceeds a certain amount, usually 51%, she will be barred from recovering. Private nuisance. A private nuisance is any substantial and unreasonable interference with the use and enjoyment of property. The interference must be substantial. An interference is substantial if it would be offensive or annoying to an average member of the community. This is an objective standard. There is no requirement that the plaintiff actually be annoyed, nor is there any special allowance if he or she is actually annoyed or offended. The activity causing the nuisance must be unreasonable. This is a balancing test. If the utility of the activity outweighs its interference with the plaintiff's property rights, it is reasonable. Otherwise, it is unreasonable. The activity must actually interfere with the use of land. Generally, this has been expressed as requiring that the activity have a trespass component. Interfering with access to light traditionally has not met this standard. However, the introduction of any particulate matter or sound waves on the plaintiff's property satisfies this requirement. Here, L will claim that the smoke is only offensive in that it blocks light, and that therefore there is no interference. The substantial and unreasonable interference must directly interfere with the use of private property. Interfering with public spaces does not create a private nuisance. Public nuisance. Public nuisance is any activity that interferes with the health or safety of the public at large. Standing. Public nuisance has strict standing requirements. In order to collect under public nuisance, a private individual must demonstrate that they have suffered a harm that is different in kind than the general public. A harm different in degree is insufficient. Trespass. A trespass is any physical occupation of real property without permission. A trespass only occurs if the trespasser actually intended to occupy the land. The trespasser's knowledge about the ownership of the land is irrelevant. A mistaken belief that they had the right to enter the land is not a defense. In essence, trespass is a strict liability offense. The trespasser must be physically present on the property. The property owner must not have consented to the trespass, impliedly or expressly. There is no requirement of actual harm. Nominal damages are recoverable. Private necessity. Private necessity exists when exigent circumstances cause the trespass. For example, docking a ship on a storm constitutes a private necessity, or swerving to avoid an obstacle on the road. Private necessity allows the avoidance of nominal damages and ejectment. As such, the trespasser is traditionally held responsible for any actual damages that occur as a result of the trespass. Public necessity. Public necessity exists when the trespass is necessary to prevent harm to the public at large. Unlike private necessity, the landowner cannot collect actual damages from public necessity. Implied easement by prescription. Easements grant the dominant estate, or a party in limited circumstances, the right to use the subservient estate for limited purposes. An implied easement has no writing requirement. An easement by prescription functions similarly to adverse possession of a property, but only for a limited use. In order to establish that there is an easement by prescription, the seeker of the easement must demonstrate 1. Continuous use of the subservient estate, 2. For a statutory period, 3. That was open and notorious, and 4. Hostile. Unlike in adverse possession, there is no requirement that the easement holder have had exclusive use over the property, since the easement does not eliminate the property owner's rights entirely. The use must have been without the permission of the landowner. Otherwise, there is a freely revocable license. Taking, condemnation. Government entities have the right to take property, providing that just compensation is provided. In order to take, the government must merely show that the taking is rationally related to a legitimate government purpose. Generally, the compensation must merely be equal to the full market value at the time of the taking, including the value of any improvements. Fair market value can be determined by appraisal, or by the sale of comparative properties. Relocation costs. The government may be liable for losses resulting from reliance on the assumption that there would be no taking. For example, the government may be required to compensate a party for the cost of recent improvements. However, the government is not responsible for other costs, such as the costs of finding a replacement property. Negligence. A negligence claim consists of duty, breach, causation, and damages. All elements must be present for a plaintiff to recover. Duty. A person does not generally owe a duty to act. However, if a person acts, they owe a duty to act as prudently as the reasonable man would, and is liable for harms that come to foreseeable plaintiffs for the failure to act with reasonable care. In the majority Cardozo view, a foreseeable plaintiff is anyone who is in the zone of danger. Under the minority, Andrews view, a foreseeable plaintiff is anyone who is harmed if the defendant could have foreseen harming anyone, even if the person harmed was not the type of plaintiff the defendant foresaw harming. Breach. Assuming D. Negligence per se. Under negligence per se, a defendant has breached his duty if he violated a 1. Statute addressed at the behavior. 2. The statute was designed to protect against a specific type of harm. 3. The statute protected a specific class of people, and the plaintiff harmed is in that class of people in a way the statute was designed to protect against. Causation. Actual. For a negligence claim to succeed, there must be both actual, but-for, and legal, proximate, causation. But-for, actual, but-for causation means that but for the defendant's action, the plaintiff would not have been harmed. Proximate. The breach must also be the proximate cause of damage. Proximate cause or foreseeable causes. There can be intervening events between D's breach and H's harm as long as D's breach was still a substantial factor in causing D's harm. Superseding. However, superseding events breach the chain of causation. Superseding events are unforeseeable events, such as a criminal act or act of God. Damages. The damages must have been caused by D's breach. Abnormally dangerous activity. Abnormally dangerous activities are those that 1. Present a substantial risk of bodily harm or death. 2. Are uncommon to the area, and 3. Cannot be mitigated by sufficient care. Damages, joint and several liability. In the majority of states, plaintiff can recover from defendants in joint and several liability. That means he can recover all of the damages from either of the defendants. However, he cannot double dip and recover anything more than 100% of his damages. A jury will apportion the fault. If the jury assigns 70% of fault to A and 30% of fault to D, and plaintiff recovers 100% from A can demand D reimburse him 30%. Assault. At issue is whether Jack assaulted Nancy when he threatened to kill her when they were talking on the phone, or when he raised the chainsaw up while they were talking in the yard. Assault is the intentional creation of apprehension in another of immediate bodily harm. Apprehension means that the victim must be aware of the threat against her. Assault requires more than just threatening words alone. The words must be accompanied by an action. Conversely, words may negate immediacy by attaching a condition or time frame to a threat. Intentional infliction of emotional distress. Intentional infliction of emotional distress, which requires for a defendant to commit outrageous conduct that causes severe distress in a plaintiff. Although IAED does not require a showing of physical distress symptoms, there must be at least some allegation that the plaintiff suffered from severe distress. Battery. Battery is the intentional infliction of bodily harm caused by harmful or offensive touching to another's person. A person may be construed liberally to include objects connected to a plaintiff's body, such as her purse. Trespass to land. Trespass to land occurs when the defendant unlawfully enters the land of the plaintiff. Trespass to chattel and conversion. Trespass to chattel and conversion are property torts that occur when the defendant damages or steals the property of a plaintiff. The difference between trespass to chattel and conversion is one of degree. Trespass to chattel occurs where property is harmed but not completely destroyed, and conversion occurs when the property is destroyed or stolen. Defense of others. A person may use reasonable force in defense of another when that person believes that the other is in danger of immediate bodily harm. The force used must be proportionate to the threat. Mistaken self-defense, or defense of others, is still a valid defense to an intentional tort so long as the mistake was reasonable. Transferred intent. Under the doctrine of transferred intent, the intent to commit an intentional tort, such as battery, against one plaintiff may be transferred to another plaintiff if the harm actually befalls the second plaintiff. Negligence. In all negligence actions, the plaintiff must establish a prima facie case for negligence, which generally is composed of 4 elements. I. Defendant owes a duty to plaintiff. 2. That duty is breached. 3. The breach is the actual and proximate cause of the injury. And 4. Damages to the person or property. Duty. The duty owed to the plaintiff is a general duty to all foreseeable plaintiffs. Further, the majority, Cardozo, is that the duty extends only to plaintiffs within the foreseeable zone of the danger. Conversely, the minority, Andrews, is that the duty extends to all plaintiffs. Also important to the first element is what the duty actually is, the standard of care. There are many different standards of care that will be discussed below. The first possible standard of care is the common law one. A person must act as an ordinary, reasonable, and prudent person would act in the same circumstances as the defendant. Such a standard does not take into account the mental capacity of the defendant, but may take into account any physical incapacities. The court may also take into account any expertise or knowledge that he has. Breach. Whether a duty and standard of care is breached is fact-specific, but can look to industry custom, regulations or health codes and any other relevant information. Causation. For causation, plaintiff must establish both actual and proximate cause. Actual cause is causation in fact, but for the defendant's actions, the plaintiff's injury would not have occurred. Proximate cause is a limitation on liability, and says that the injury must be foreseeable. The defendant is generally liable for all harm that is the normal incident of and within the increased risk of his conduct. Damages. Lastly is damages, which must be to the person or property. Negligence per se. Negligence per se is that the generally common law standard of care may be replaced when there is a government regulation, statute, or as is here a health notification, that imposes a criminal penalty, which includes a fine. If negligence per se is established, then it is conclusively presumed that the negligence elements of duty and breach are satisfied. To establish negligence per se, the regulation must be violated without excuse. The plaintiff must have been within the protected class, meaning the type of person the regulation sought to protect, and lastly that the plaintiff suffered the type of injury that the regulation sought to avoid. Vicarious liability. The owner can be liable for the negligence of his employees, and even possibly the acts of independent contractors, under vicarious liability. Vicarious liability says that the master may be liable if the acts of his servant were within the course of employment. Generally, an owner or master will not be liable for the intentional torts of his servants or employees, unless the intentional tort was natural in the nature of the job, performed at the request of the master, or for the master's benefit. E/IC. Generally, to determine whether someone is an employee or independent contractor, the courts look to several factors: degree of skill required in the job, who provided the tools and facilities, duration of the relationship, did principal control the means of performing the task, was there a distinct business, etc. An owner is liable for the acts of his independent contractor in 2 situations: I, when the independent contractor is performing an inherently dangerous task, and 2, when because of public policy, the principal's duties are non-delegable. Negligent hiring. The owner owes a duty to his patrons to employ persons that are qualified and will perform the job responsibly. Abnormally dangerous activity. A defendant will owe a plaintiff a strict duty of care, regardless of the conduct of the particular defendant, when the defendant undertakes an abnormally dangerous activity. An abnormally dangerous activity is one with a high risk of harm that is not commonly found in the community, which has a risk that cannot be eliminated with due care. The utility is usually lower than the risk of harm. The defendant is liable if the dangerous character actually and proximately causes the plaintiff damages. Strict products liability. A defendant is strictly liable in tort when the defendant manufactures, distributes, and/or sells a product that is unreasonably dangerous and thus defective, and the dangerous character actually and proximately causes harm to a plaintiff. Commercial seller. A proper defendant for strict products liability is a commercial seller of a product. This includes all parties in the chain of distribution. Proper plaintiff. Strict products liability does not require privity or a contractual relationship between the defendant and the injured party. A proper plaintiff is thus a buyer, a user, or even a bystander that is harmed. Defect. There are 3 types of defects in products liability: a manufacturing defect, a design defect, and a failure to warn defect, which is a subset of a design defect. Manufacturing defect. A manufacturing defect is a defect caused during the manufacture of the product, whereby the product becomes unreasonably dangerous as a result of a problem during the manufacturing process. The defect is a result of a one-off problem, where the product emerges more dangerous than the other products that are manufactured with it. Design defect. A design defect occurs when a product as designed is unreasonably dangerous, and is measured in terms of whether there is a reasonable alternative design for the product that makes it more safe without impairing its utility and function, and without making it unduly expensive so as to price the defendant out of the market. Failure to warn defect. If there are either no warnings or inappropriate warnings on a dangerous product, this is a type of design defect. Actual cause. There must be a showing not only that the product was dangerous, but that the dangerous property actually caused the harm to the plaintiff. The defect must have been present while the product was in Darla's control. Proximate cause. The harm must also have been proximately caused, meaning that it was foreseeable that the harm would occur, and that the defendant created the scope of risks. A strict products liability defendant is liable for all foreseeable misuses of a product, so a misuse that is foreseeable will not cut off the chain of liability, because it is not an unforeseeable independent or abnormal dependent event such as would break the chain. Damages. Typically, products liability actions will only allow a recovery of personal injury or property. Assumption of the risk. One knows of a risk and voluntarily proceeds in spite of it. Implied warranties of merchantability. A product is deemed merchantable for its intended purpose.